The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, a weekly podcast on the Federal Courts of Appeal from the Institute for Justice's Center for Judicial Engagement. I'm your host, John Ross, joined today by Clark Neely and Evan Bernick. If you like what you hear, be sure to sign up to our email newsletter of the same name for a weekly dose of circuit court action. Subscribe at ij.org/shortcircuit. This week on the show, state bans on assault weapons, a heartening display of engagement on a Fourth Amendment question, and a defendant's non-voluntary guilty plea. Clark, kick us off.
First case comes up out of the Second Circuit. It involves various gun regulations in New York and Connecticut. In a nutshell, the regulations ban certain kinds of quote-unquote assault weapons, ban high-capacity magazines, basically over 10 rounds. And then one feature of New York law required basically that even if you have a 10-round magazine, which is legal, you were not allowed to put more than 7 rounds into it, basically because they wanted to have a 7-round magazine ban, but nobody makes 7-round magazines. That would have been ludicrous. So they ban magazines larger than 10 rounds, but then forbid people from putting more than 7 rounds into the magazine. Those regulations were challenged by pro-gun groups, and the district court rubber stamped them, which is generally what district courts do. And it went up to the Second Circuit for application of the Second Amendment standard not really articulated in the Heller McDonald case. We know they took rational basis review off the table. And the question for the Second Circuit was basically, how low a standard of review can you apply and still not technically be rational basis? And that's essentially what the court did.
All right, so the standard of review that was nominally applied in this case is intermediate scrutiny. And normally intermediate scrutiny, the formulation is an important government interest and you need to have substantial narrow tailoring. That means that the government needs to come forward with evidence and it needs to support its claims with evidence, and it needs to demonstrate that it has pursued means that were reasonably narrowly tailored to that. It has to consider alternatives.
And what sort of evidence did the states bring forth, Evan?
Well, the court in this case emphasized substantial deference to legislative fact-finding and the legislature's predictive judgments. The problem with that in this case is that there was no legislative fact-finding and there were no predictive judgments made by the legislature. This bill was passed a day after it was proposed. There was no opportunity for legislative fact-finding, and all of the evidence that found its way into the record was created in the context of litigation. That is a challenge to this law. So the court is emphasizing legislative deference, but they're actually deferring to the Attorney General and the Governor.
Yeah, one other thing to add about that, too, is that the way the court handles evidence in this case is very interesting. Imagine that instead of a scary weapons ban, which is what an assault weapons ban is, instead of a scary weapons ban in this case, we were talking about a ban on automobiles. Obviously, the government could amass substantial evidence that automobiles are very dangerous. In fact, they kill more people every year than guns do. So if a court was just going to take account of whatever the government submits and then systematically ignore or discount what the plaintiffs trying to maybe defend the use of automobiles would submit, obviously automobiles are really useful. They're usually used lawfully. And actually, both of those things turn out to be true about guns and specifically assault weapons. So if you looked at all of the evidence, what you would see is, occasionally assault weapons are used for bad purposes, crimes, and to kill people, but really not all that often. And compared to the frequency with which they are used and possessed for lawful purposes, it's not even close comparison. So what the court does to kind of avoid that is tells us about the government's evidence, and it does so in a vacuum. We don't hear anything about the plaintiff's evidence or how widespread the use of these guns for lawful purposes is. And so basically everything the government puts in gets to count in its favor, and nothing the plaintiffs put in gets to count in their favor. It is very, very reminiscent of rational basis review. I wouldn't consider this a form of heightened scrutiny, even though that's what the court calls it.
Right, and this isn't just, our opinion stating what we think intermediate scrutiny should be. This is what the Supreme Court has said. I mean, in case of City of Los Angeles v. Alameda Books, this court set out a 3-part test for applying intermediate scrutiny, and it explicitly said that if the government comes forward with evidence and plaintiffs respond with evidence that casts doubt on the evidence presented by the government, that, in effect, puts the burden back on the government. In this case, what the court did was basically say, okay, the government has produced evidence, we're done. Essentially, this is intermediate scrutiny in
name only.
In name only.
So what's going to happen, it appears, is that this opinion will further widen what is already a large and growing split among the circuit courts. you've got most circuit courts that apply something like this, basically a kind of a dressed-up version of rational basis review. And then you have a handful of courts that apply genuinely heightened scrutiny, and that split is inconsistent, irreconcilable, and growing. And the question will be, when will the Supreme Court get involved again, not if. And it may be a while, but this is definitely going to require attention from the Supreme Court.
Okay, let's move on to the next case, which comes out of the Fourth Circuit. Evan?
So this case, like previous cases that we've discussed in this context, is about whether the Fourth Amendment applies if you live in a high-crime neighborhood and you're nervous around police. In this case, you have a group of police officers who are staging the execution of a warrant on a suspected drug house. They come across somebody in the parking lot, well, two people.
Keep in mind, this is the parking lot of the business across the street from the alleged drug house. It's not the parking lot of the house they're raiding. So the police are staging in a parking lot of a business across the street, and they see a couple of people with broken down cars.
For all they know, completely unrelated to anything that they're planning to do. They confront these two people, and in response to questions from police, they appear visibly nervous. They explain that, the guy says that he's there because the girl's car broke down and he's picking her up. The police officers become suspicious. They eventually search one of the cars and they turn up drugs. And the question is whether they had reasonable suspicion to detain these people and say that they were not free to leave, simply because it's a high-crime area, it's a parking lot, it's night, and they're nervous around police.
And there's a part of the story that really needs to be emphasized, because it's really important when the detention occurred, because, of course, that's when the Fourth Amendment issues attach. And it happened very early on. Literally, there was just a discussion between one of the police officers and the man who said he was there to help with the broken down car. And they barely exchanged two sentences.
It lasted less than a minute.
Lasted less than a minute. And the police officer who did that interview had some other business to take care of with the raid. So he says to a colleague, come over here and guard these two. This guy's not free to leave. And that's when a detention occurs. And the reason it's so important is because if the initial detention was not supported by reasonable suspicion, then everything that follows is at least potentially the fruit of a poisonous tree. The poisonous tree, of course, being the unconstitutional detention in the first place. And that's what's at issue in this case, is whether that initial detention was legitimate under the Fourth Amendment. Because, just to follow it up, what happened was they did end up searching the man. They ended up searching the car. They found some money. They found some drugs. And that's where the charges came from.
Where did the district court land on this, Evan?
Well, the district courts signed off on it. They said, "Hey, if it was really true that your car broke down in this part of the neighborhood, and the police came by, there's no reason for you to be nervous or evasive. You would welcome the police coming there and asking you. Keep in mind that there are 10 police officers here. Can we help?" And the appellate courts looked at this and said, "Look, there's just simply not enough to say that these officers had an objective, particularized basis for stopping these people. We're not going to say that simply because you're nervous around police, that should give reason for police to detain you, ask you questions, and eventually search you."
The opinion more or less ends with a wonderful statement that it would be great if more judges took this to heart, and I just want to read it. The panel says, "As we have warned against, we will not use whatever facts are present, no matter how innocent, as indicia of suspicious activity. The government must do more than simply label a behavior as suspicious to make it so." That is a very important point, and we should realize that there are many people for whom it is perfectly rational to be nervous in the presence of a police officer, even if they have done nothing wrong. That's unfortunate. There are a variety of reasons for it, but for judges to ignore that and pretend as if it's not true is to do an injustice to those people and to fail to uphold both the spirit and the law of the Constitution, including the Fourth Amendment. And so this panel should be praised for embracing reality in its opinion and not high-sounding but false principles.
A few weeks ago, we talked about a case where a gentleman was convicted after slouching in a high-crime area. Does this sort of present a split that the Supreme Court might be interested in on the Fourth Amendment?
Potentially. I mean, what needs to be stressed here is that the court in Terry, and to the extent that it's followed that and been consistent with the principles espoused in Terry, has said that you need objective, particularized evidence grounded in reality before officers can detain people and search them. And if all that's required is your presence in a high-crime neighborhood and nervousness around police, that limitation goes out the window. Because
that's a great point. Look, we are a free people. We are not subject to being detained and searched by law enforcement officers just because we happen to be out in public. So if we start with that as the baseline requirement, that there has to be some particular reason for stopping people, detaining them, and ultimately searching them, then it is A, important for judges to draw that line, and B, not refuse to draw the line simply because it is difficult to do so. Yes, there will always be a certain element of subjectivity or uncertainty in drawing that line, but if our judges refuse to draw that line, we will no longer be a nation of free people. The Constitution demands more.
Okay, let's move on to the next case, which comes out of the First Circuit. Clark?
This is an absolutely appalling travesty and miscarriage of justice that fortunately gets fixed at the First Circuit appellate level. What happened was several men were found in a car, pulled over in the early morning hours in Puerto Rico. There were several weapons in the car. They were all Glock pistols. One of them had been modified to fire full auto. And long story short, what happened is that one of the passengers in the back seat was charged with possession of all of the firearms. He was charged with being a felon in possession because he had a criminal record. He was charged with being in possession of a machine gun because one of the pistols was modified to fire full auto. And he was charged with being in possession of a firearm near a school because there was a school within 1,000 feet. He decided to plead guilty. And there are certain requirements in order for a guilty plea to be validly accepted. And basically, the district court judge has to go through and make clear that on the record that the defendant understands not only what he's being charged with, but what the government would have had to prove in court in order to convict him in an open trial. And that's where this case went off the rails.
Yeah, the district court didn't do anything even remotely resembling that. They didn't ask Figueroa, that's the person in question, whether he had read the indictments, nor whether he had reviewed it with his attorney or understood it. The court asked confusing, internally contradictory questions and failed to follow up. You look at the record in this case, and it's just absolutely appalling.
It's not just that. The court affirmatively misstated the government's burden in some of the colloquy with the defendant.
Coaxing him, yes.
What's that? Coaxing
him to believe that the extent of mental knowledge that he had to be convicted of these crimes was something other than what it was.
Yeah, and the Court of Appeals emphasizes that these elements were missing in the government's proffer. So in a way, it's the government's fault for, at least the government initial fault for not putting the elements in the proffer as it should have done. The thing that really comes through in this, besides making you wonder, oh my God, how often does this happen? But the thing that comes through is that there was only one advocate really in the courtroom, and that was the guy wearing the robe. So you've got the defense attorney who's sitting there allowing all of this travesty to happen. He's referred to later in the First Circuit opinion as a potted plant, but the prosecutor wasn't any better. He wasn't doing his job either. The only one who's actually working to make sure this guy gets convicted is the judge, and he's doing so in a way that is not neutral the way a judge is supposed to be. He's really serving as an advocate. He's really working to elicit the necessary agreements and information from the defendant to ensure that he gets a conviction. And when you read the exchanges, and the opinion has all these exchanges, it's very clear that this defendant really doesn't get what's going on, and he is being, as Evan suggested a moment ago, coached into giving the right answers by the district court. It is appalling.
Yeah, I'll just give one example of this. Count 2, this is the stolen weapons charge, requires proof that he knew or had reasonable cause to believe that the firearm was stolen. Now, he actually denied knowledge that the firearm was stolen. The court responded by saying, well, there was a possibility that when you bought it or wherever you bought it or found it or took it, God knows how it got there, it could have been stolen. And he says yes. And that's
he being
sufficient.
The defendant says yes.
Right. And the defendant says yes. And that's regarded as sufficient to think that there was that he had sufficiently pled to this charge.
Well, for the non-lawyers, explain why that's not sufficient.
Well, look, we are supposed to take these plea bargains, or I'm sorry, these pleas seriously. This man was sentenced to approximately 6.5, I think 7 years in prison, so he's going away for a long time. We need to make sure that he understands what he is admitting to. And by the way, there's real reason to believe he might not have been the one in possession of these weapons. There were like 3 people in the car, 3 guns. He was not found to be carrying any of them. So it's not as if he comes out of the car and he's got guns shoved in his waistband. It's a real serious question whether this guy actually committed any criminal activity, and he's being railroaded into a plea, not even by the prosecutor. He's being railroaded into a plea by a district court judge while his defense lawyer sits there and does nothing. Thank goodness there was an engaged Court of Appeals on the other end to prevent this travesty from occurring. I want to add actually one other thing, and that is we've talked a lot about how judges in rational basis cases have been ordered by the Supreme Court to effectively serve as advocates for the government, inventing justifications for its conduct when necessary. What we see in this case is a judge acting as an advocate in the last place where judges should be doing that, in a criminal proceeding to help elicit and confirm a plea from a criminal defendant. We must purge from our system, our justice system, all vestiges of judges serving as advocates for government, because I firmly believe that if we tell them to do it in one setting, rational basis review, we should not be surprised to see them doing it in other settings. There is no setting in which a judge should ever serve as an advocate for either party, certainly not the government.
Okay, that concludes the show. Thanks for listening, and be sure to tune in next week for more cutting-edge constitutional analysis. In the meantime, be sure to follow Clark and Evan on Twitter. Their handles are @ConLawWarrior and @EvanBurnick. Until next time, this is John Ross from the Institute for Justice, remonstrating with you to get engaged.